Good afternoon, ladies and gentlemen. Welcome to CILEX's summit on the Legal Education and Training Review.
The LETR recommended collaboration on a number of issues, including the development of common standards for qualification and the formation of a legal education council.
The last thing we need in the legal sector is yet another body with its secretariat and its meetings and its consultation papers and so on. We've got quite enough of that already.
We are determined to press on against the most ambitious timetable, and we will do whatever we can to work with our colleagues to ensure that there is some harmonisation in approach.
That's my key thing today. If we think we are collaborators, if we want to collaborate, there's a very straightforward way to do it, and we should be doing that work on competencies together.
It seems to me, speaking personally rather than for the board, but the scepticism about establishing a council is absolutely right. Not just for the reasons stated about not adding to the alphabet soup, but actually just not to divert effort for a year into working out where the body would sit, what its constitution was, instead of getting on with addressing the issues coming from the report.
Beware of the babies that may get thrown out with this particular batch of the bathwater.
Both CILEx and the Council for Licensed Conveyancers and the students that they've developed over the years have kind of done that in a form of an apprenticeship, very much aligned to earning while they're learning.
I think there are certain benefits to be gained from the apprenticeship route, and certainly those that have used apprenticeships in the past have found that it does increase loyalty to the organisation that the apprenticeships work for, but also increases productivity too.
One of the reasons why we came to CILEx to engage with them was because we were aware of the number of graduates who, with or without the LPC, were effectively doing paralegal work employed by people who had no interest in training them.
But we do think that it's important, as it is for other parts of the sector, to develop consistent outcomes and standards for paralegals. If those are important for solicitors and barristers and other regulated professionals, why are they not important for paralegals as well?
So if you start regulating paralegals and setting outcomes, etc. for them, immediately there will grow up another body of people who haven't quite made it as paralegals.
I think quite a lot of the competencies will need to be demonstrated within the legal context, not least all of those around professionalism and ethics and so on, which you can only contextualise in legal practice.
One's responsibilities to the court, one's ability to understand the client's needs, how to put the client first, how to maintain client confidentiality, how to recognise and avoid conflicts of interest, and particularly to recognise them when they emerge unexpectedly as a case progresses, how to organise one's time, meet deadlines, work in a team. All of these things I think are very important.
Unless the courses or the lectures or whatever form of the training or education takes, unless it has intrinsic value and it's relevant, it's pointless.
There are a wide variety of roles within the financial and legal services sector, and it's important to see those as just as valid as becoming a solicitor.
We are, after all, preparing people for future practice, not for current practice. And it seems to me to make sense to take a broad view of what the possibilities might be, and to make sure that we do turn out people with at least some foundation knowledge around the things that are going to be challenges and opportunities for them in the future.
If we get the day one levels correct, does it matter how anyone got there and how long it took them?